My name is John Oberdorfer, and on behalf of the Patton Boggs Foundation, I want to welcome all of you. The 2008 Patton Boggs Foundation Fellows, our distinguished speakers, our friends from the press, and our colleagues from Patton Boggs, and especially Lorianne Updike, our moderator, and her colleagues at the Constitutional Sources Project, which creates and maintains the first free comprehensive library of constitutional sources. To date, the Patton Boggs Foundation's primary activity has been to provide fellowships to law students to work on public policy matters during the summers, either for state, local, or the federal government, or for a public interest group. This year, we have 16 fellows from 11 different law schools who are working all over this country and in 3 countries in Africa. The foundation and its Associate Advisory Committee are now adding a new activity, a series of events addressing legal issues of our time. This is the first, and what a beginning it is. Linda Greenhouse of the New York Times, in her final column, after covering 2,691 Supreme Court decisions during her illustrious 30-year career, singled out 3 decisions as extraordinarily important. The case we are going to hear about this morning, the District of Columbia versus Heller, is one of the 3. And Ms. Greenhouse characterized it as the triumph of originalism. She captured it, as she captured so many cases, this way. Justice Scalia for the 5-4 majority and Justice Stevens for the dissent each dissected the history of the Second Amendment. They came to opposite conclusions, but proceeded on the premise that original understanding of the amendment's framers was the proper basis for this decision. We are pleased, so pleased this morning, to have with us the 2 lawyers who argued the case to the Supreme Court, Walter Dellinger for the District of Columbia and Alan Gura for Mr. Heller. Many, if not all of you, know or know of both of them. Briefly, Walter clerked for Justice Hugo Black. He's a former Solicitor General, a distinguished Supreme Court advocate, and a member of the O'Melveny and Myers law firm. Alan clerked for Federal Judge Boyle in North Carolina, later became the Deputy Attorney General for California, and served as counsel to the Senate Judiciary Committee before forming his own firm, Gura and Posteactment, in Virginia. For our moderator, Lorianne Updike, founder, president, and executive director of the Constitutional Sources Project and a teacher of constitutional law, the heavy reliance by both sides in this case and by the principal opinions on originalism was a win-win, a dream. Lorianne will engage the 2 Supreme Court advocates in a discussion of the case and how its focus on originalism influenced their respective strategies and the outcome. Lorianne, pleasure to have you run this panel. Thank you. Pass the 2 mics.
Thank you, John. That's one too many microphones for my tastes. It's a pleasure to be here, and especially with our distinguished panelists. Again, my name is Lorianne Updike, and I head up the Constitutional Sources Project. We're here today to talk about Heller from a very different perspective than what has currently been discussed in the media. Instead of talking about whether Miller was precedential and the Supreme Court's first decision on whether or not the Second Amendment guarantees an individual right to bear arms, we will talk about Heller from a documents perspective. As I was standing in line, waiting to get into the Supreme Court to enter in and listen to the decision of the case, somebody from the Brady Center turned to me and said, yes, this is really the battle of the documents. And right after I heard her, I turned and saw the petitioners with their big signs, and one of them said, had a quote by Patrick Henry. And I thought to myself, this truly is the battle of the documents. One reason why Heller is important, other than simply being a case about guns, which is precedential for the country, Heller is important because it has now set a precedent for how the Supreme Court and other courts have used the sources of the Constitution. Now, as we've seen, this opportunity to interpret the Constitution firsthand for the first time happens once in a lifetime for many judges and for many justices. In U.S. versus Reynolds, we had the same experience where the Supreme Court decided the First Amendment's free exercise clause, whether or not that allowed those practicing polygamy to do so, whether or not free exercise guaranteed individuals the opportunity to practice religion, and if that included acts rather than opinions or beliefs. This same practice, then, of using the founders' documents was incorporated into Heller. So in this panel, we will discuss the court's use of the documents and their strategy, as well as the panelist strategy in doing so, what the court should and should not have done in Heller. And we'll base this on 4 questions. Those who are here in the room and those who are participating via webcast will be able to follow along. The 4 questions which we will address are: what test should be used to determine whether the founders' documents or constitutional source material should be used? Second, what hierarchy for constitutional sources should apply? And then specifically, what sources should have been used or should not have been used in Heller? And then what sources and or founders should be excluded? Finally, what citation methods should be used? Because this happens so rarely, because source materials are used so rarely in constitutional interpretation, these questions have never previously been addressed. And this panel is here to discuss these questions. I'd also encourage you to submit your questions by 5 minutes to the hour for those who are participating live, and for those also on the webcast participating. Please submit your questions, and we'll go through those for about half an hour after 9 o'clock. I think we're going with Walter first. Is that correct?
I'm happy to go either way.
Okay.
Well, let me fight the premise of the program just a bit, because I do, when I look back on Heller, think once again about how the court got it right in U.S. versus Miller, and the degree to which the court stepped aside from having to overrule Miller. Now, overruling Miller is a choice, and the fact that only the government appeared in the Supreme Court is a reason for weakening it. But Miller actually looked at the relevant sources in the Constitution and understood it. And I was asked after the argument, some people were surprised we didn't just give up on the Second Amendment question of whether there was an individual right free from militia service and go right to the question of reasonableness, the only chance that many thought the district had of prevailing. And my answer was, I thought it would be insulting to the court that the last time the court had addressed the issue, it had unanimously held that the Second Amendment arises in a context of responding to the militia clauses in the Constitution, and that to assume that when the court has not addressed a question since then, to just assume because of the political zeitgeist that there are justices who have not addressed the issue, who are prepared to overrule a 1939 decision, when there's nothing intervening to demonstrate that except a cottage industry of interpretation, struck me as insulting to the court, and that at least we should be able to show that it was a close question. Now, the big winners in Heller were ConSource, because it is a document-rich production, and this was their dream case, where the whole theory of ConSource would be that having a repository of all of the documents, not just the Constitution and not just Madison's account of the debates in the summer of 1787, but all the rich surrounding materials would be, in fact, useful. And it was like a dream come true to see that this was the case where the number of amicus briefs and the number of documents cited and the use that people made of ConSource was really extraordinary. Joel Gura was the other big winner, because he did an extraordinary job in his argument before the court, and one of the 3 most important cases, as Linda Greenhouse sees it, of the last 30 or 40 years, with really an extraordinary performance, and justified Bob Levy's faith in him as someone who would know this issue and who should not be asked to step aside for some advocate who had done a large number of cases before the court. And finally, I think it was a great triumph for Justice Scalia. What a dream come true to be able to write on a constitutional blank canvas. I mean, I can just imagine Scalia having knowing he had the support of 4 of his colleagues, and having a complete tabula rasa, as long as you're going to read United States versus Miller out of the U.S. reports, you're then at least starting with a completely blank slate on which to do a new interpretation of the amendment. And I think, contrary to almost all of the media reports, that Justice and I think much to the liking of Joel Gura and those that supported the cause, I think it's more of an absolutist opinion than others do. That the approach of Justice Scalia is that Justice Black takes to the First Amendment. But I'll come back to that because I do want to start with sources. It seems to me that the most important sources are right there in the Constitution, and that there were 4 important provisions of the Constitution that should have been on the table before the Supreme Court. Clauses 16 and 17 of Article 1, Section 8, Clause 17, the District of Columbia Clause, and the Second Amendment. And I say that because I found the case frustrating in the sense that it's very hard to do history in the Supreme Court. The case doesn't really start with the Second Amendment. To me, the most important sources are those that were considered between the proposal of the Constitution on May 17, 1787, when the work of the summer done, the Constitutional Convention sent the Constitution forth to the states for ratification. And the ensuing period between 1787 and 1791, when the Second Amendment and the rest of the Bill of Rights was proposed and ratified, that critical period defines what the Second Amendment was all about. It was amending the militia clauses of the Constitution. And what is hard to recall is how shocking the militia clauses were to those that reacted to the Constitution when it was proposed at Philadelphia. Remember, the coming together of the American colonies was more difficult than we can easily now imagine. John Adams wrote home in 1776 for the First Continental Congress, "We meet together 50 gentlemen, all strangers, not acquainted with each other's ideas, views, designs. We are therefore jealous of each other, fearful, timid, skittish." They saw themselves as defenders of histories accomplished. They'd had a significant degree of self-government in the colonies with British control of foreign affairs and other hateful measures, but a large measure of self-government. And they fought the war as allies, not as a union. They didn't have uniforms, and they formed a confederation at the end of it for 11 years. And when they met in the Constitutional Convention in 1787 and proposed a new constitution, it was shocking. It created a national government with the power to operate directly on individuals, authority over all the lands from the Atlantic to the Pacific, the authority to tax, none of which there had been no central government that had any of those powers in the first 11 years after the Declaration of Independence. And particularly shocking and hard to recall now is the control over military force. The new Constitution gave Congress for the first time the power to create a standing army because it had the power to tax directly and to create an army and a navy. All right, well enough. But the contrary to that was the militia. In each state, people, ordinary citizens, put down their tools and implements of trade, became a citizens' army, dealt with the threat, went back to their normal occupations. And state control over the militias was considered the palladium of liberty. The new Constitution said that Congress shall provide for organizing, arming, and disciplining the militias. Arming, meaning to disarm or to arm. And that while the states would train them, they would have to train the militia according to the discipline prescribed by Congress. The ratifying debates, this was an important part of the ratifying debates, as the states said, Not only are you going to create a national army in this new Congress, you're going to take from us the power to have our own citizen militias subjected to control of the national government and give the national government the power to disarm the state militias. And the amendment proposals were to strip Congress's authority over the state militias and give that authority back to the states, where the people themselves could keep and bear arms for their own defense. Madison, what's interesting about the Second Amendment is that Madison was uncomfortable with the demand to give control over the militias back to the states, and perhaps wound up being too clever by half. I think he was somewhat grudging in the degree to which he protected state authority over the militia. So his version of the Second Amendment, the first proposal, I don't know, it's probably out of sequence. Madison proposed the Second Amendment as part of his package to the first Congress. Where's the silver mic? Oh, it's the silver mic. Okay, I need the silver mic here. His proposal said, speak directly into the silver mic. No, that's wrong. No. Madison's proposal said, and I began the argument with Madison's proposed text of the amendment. He said, the right of the people to keep and bear arms shall not be infringed, a well-armed and well-regulated militia being the best security of a free country, but no person religiously scrupulous of bearing arms shall be compelled to render military service in person. So it was unmistakable from the amendment proposed by Madison that it was about military service and protecting the right of the people to keep and bear arms, but no one with religious scruples should be forced into military service. The text of the amendment changed throughout the debates, but the militia focus never changed. And that is essentially what United States versus Miller held, looking at those sources. Miller dealt only with the nature of the weapon, but that's because that was the only issue before the court. U.S. versus Miller comes up in 1939. It's an indictment for having a sawed-off shotgun in violation of federal law. And the defendants moved to dismiss the indictment on Second Amendment grounds, and the district judge says, yes, this violates the Second Amendment. There's a direct appeal to the U.S. Supreme Court. And the court has only one fact in front of it: the weapon. That's all the court has. So, of course, that's all they deal with. That's all that's on the face of the indictment. And the court says in U.S. versus Miller that in the absence of that this was about protecting the right of the people to have a militia, and that in absence of any evidence tending to show that possession or use of a shotgun having a barrel of less than 18 inches has some reasonable relationship to the preservation or efficiency of a well-regulated militia, we cannot say that the Second Amendment guarantees the right to keep and bear such an instrument. So the ratio decidendi is there has to be a relationship to the militia. That was the obviously understood meaning of the clause. Now, how are we doing on time? 30 more seconds. One of the problems, I think, of the case is that the number of bad arguments that have been made to diminish the Second Amendment over the years. The notion that it created only a collective right and not an individual right, or that the people referred to was only a limited number of people actually serving in the militia. And these are the argument that you ignore the right to keep and bear arms and focus entirely on the first clause. All these seem to me to be mistakes that were hard to overcome because you're trying to convince the court you're not making the arguments they think you're making. And that's why I began by saying that the first clause to be looked at is the right to keep and bear arms, instead of running away from that. That in every instance that phrase was used in the military context in the debates over the Second Amendment. That, of course, the Second Amendment creates an individual right. Every provision of the Constitution can be invoked in court by an individual who has a stake in the outcome of the case when the amendment has a bearing on the outcome of the case. I don't know how one ever got into this collective rights theory. And that the people did refer to the people collectively, to all of the people, not just those serving in the militia, as long as the right was one related to militia service. And indeed, I think the Second Amendment would be a basis for striking down federal legislation to the extent that it interfered with a state's desire to have people trained for possible militia service. If Louisiana said we're going to train every 18-year-old in the use of a certain set of weapons, and an 18-year-old is arrested for possessing a weapon on his way to his Louisiana training program because they no longer trust the federal government after Katrina to deal with disasters, I think he's got a Second Amendment claim. Always thought he had it before Heller. Always thought he had a Second Amendment claim that he was being trained for potential militia service by the state, and that weapon had been described as one that he did, and that would be a use of the amendment. Finally, I'll just say the one thing I didn't say in court that I was very tempted to say. The question always arises, well, in your view, does it make the Second Amendment a dead letter under your interpretation? To me, the answer to that question is, I don't understand the theory of constitutional interpretation that thinks it is the function of interpretation to come up with a jobs program for underemployed constitutional amendments. Thank you. Joel.
Thank you so much. Let me grab all the microphones first. I know.
Okay, here we go.
I have two here. I have this one.
How about
that
this one?
You're okay.
You okay? You got it.
Okay, great. Well, thank you so much. That was a fantastic presentation by Walter Dellinger, and of course, having argued the case, I think he argued it as well as anybody could possibly argue it for the District of Columbia, and it's a testament to his great skill that he managed to garner 4 votes for a theory which I was surprised it actually got 4 votes. The biggest shock for me in the case was that it was 5-4. I always thought the case was stronger than that, of course, and I'm very gratified that we got the 5. That's at least we got 5, and we'll take that. That's all we need. We'd always like to have more, but it's still the law at 5. Let me address first what this case revealed about the court's approach to history and to documents. There are different modes of originalism, and I think the opinions here demonstrated clearly two approaches. There's a difference between original meaning and original intent. Original meaning, the approach employed by the majority that we've seen, looks to see what the words of the document meant at the time, not just to the people who enacted the document, but also to those who were around in the society. What did this language mean at the time? And that's a little bit different than original intent, which is almost like a legislative intent exercise. Never mind the language that was actually enacted. What was on James Madison's mind? We can have sort of a historical psychoanalysis of the people who wrote this, looking for scraps of hints and clues and debates and other language to see what they were really thinking, never mind what they actually said. I believe original meaning, original public meaning is probably a better approach most of the time. It's important when we look at different approaches to interpretation that we don't get tunnel vision and don't rely exclusively on one tool to the exclusion of others. There are many ways to approach interpretation of text, and sometimes one method will work better than others, but on the whole, I think the original public meaning discussion that we saw in the court's opinion is usually the safer way to go. Remember that the object here by both sides, or by anybody who wants to interpret the text, is to give the text substantive meaning. If the Constitution only means what we think it should mean today, only means what we're comfortable with it meaning today, then it really has no meaning. It doesn't actually set forth any rules that we're bound to follow, because we can say that the words mean whatever we want, and it's just an exercise for clever people engaging in semantics to imbue an empty vessel of text with whatever they like for it to contain. If the Constitution, though, has a fixed meaning, however we define that fixed meaning, then it actually is a living Constitution in the sense that it has meaning for us today, and it's operative, and it's something that we need to pay attention to. With that, let's look at and how it is that we approach the text in the Second Amendment issue and in this case. The first source, of course, for interpreting the Constitution is the text of the Constitution itself. And if we look at the Constitution, we'll see various references to the militia, obviously a concept that perhaps we may disagree on. But it's important to note something in Walter's presentation. He kept on talking about the militias, plural, as though there's a reference to specific organizations. And sometimes we heard from the other side reference to a militia of the state. But that's not really the language in the Constitution. The Constitution refers to the militia, singular. And the militia, once it's understood in that form, is actually what the court found that it meant even in Miller and certainly in Heller, which is a subset of the population, those people who are capable of bearing arms that they would have themselves privately in ordinary everyday use, and they would come together in time of crisis or need and form a sort of a defense for society. It's true that the militia was organized at the state level from time to time, but it was not always exclusively so. Pennsylvania, for example, had a long history of private associations. Remember, in Pennsylvania, there was a very strong Quaker influence. People were not willing to subscribe to any sort of state military organization and discipline, but Benjamin Franklin prevailed upon his neighbors to form voluntary associations to defend the colony at the time from all kinds of Indian attacks, French privateers, and other sort of problems that people had. Also, during the Revolution, as we mentioned in our brief, the Patriots formed all kinds of militia organizations, and these were distinctly not state-operated. These were not run by the royal governors, and there was a long history of bitter antagonism between the royal governors, who had their own official state militia, and those well-regulated independent companies that folks like George Mason had organized, which were militia companies, but answered only to locally conjured patriotic committees and not to any sort of state authority. And we saw, as the court discussed in all the treatises following at the time, about the time of the Constitution's ratification and following, a discussion of the militia as a concept, the idea that people could act as militia in order to restore order, either in case of an emergency or if there was a tyrannical usurpation of lawful order. And if people were supposed to be able to act as militia, well, of course, they needed the right to keep and bear arms, because if they did not have their own arms, they could not participate in militia service and be trained and knowledgeable in the use of those arms. So the two provisions are harmonious. I won't get too much into U.S. versus Miller. Maybe if I have time at the end, I do want to get into the documents, because the documents here are important, and they do address some of the issues that people have. Now, when we litigated the case, we were often in a responsive posture, not just because we were respondents, but because the way that the debate over the Second Amendment has arisen. The other side had, for many years, as Walter mentioned, conjured up this sort of collective rights business. The Second Amendment is a collective right, and no matter how much Miller now is supposed to be a model of clarity, the fact is that for about 40 years, all the people who looked at Miller at the federal appellate level, they looked at it very quickly, thought that it contained a collective right prescription for the Second Amendment. Of course, in this case, we heard the city reject that, and Walter, of course, just rejected that here a few minutes ago. So Miller's instruction on collective rights is dubious. But in any event, when the collective rights business had to yield to the fact that it was the right of the people, and that's the same phrase that's used in the First Amendment and the Fourth Amendment. People have rights in the Ninth Amendment. They're not the states. If we look at the 10th Amendment, powers are reserved to the people or the states. Then the other side went on to this to the argument that they did make, which is what's been called the sophisticated collective right, or the public purpose individual right, which is the idea that yes, it's an individual right, but only to have a gun if you are actually in sort of some state military service. And we would see in law review articles and publications constantly, the other side would make some sort of original sounding language, going back in time, trying to psychoanalyze James Madison, and see that when he wrote the Second Amendment, he really meant only the right to keep arms in military service, and of course that he really intended to undo the militia clauses of Article 1, Section 8. So we are always having to respond to that. We made an argument on original public meaning. This is the text. This is how we interpret text. The preamble is worth only so much. The right of the people to keep and bear arms means this, it means that. And the court's majority adopted that approach to some extent by talking about what did it mean to keep arms? What did it mean to bear arms? What were arms? Who are the people? And going into that sort of analysis. But at the same time, the other side was focused very much on original intent, not original meaning. The original intent of Madison to undo the militia clauses. And so the documents were useful in a rebuttal posture to show that even if you are an adherent of original intent, of legislative intent, the history, the facts just simply don't add up. Let's go to the first slide. I'm not sure which slide I have first on there. I selected 3. That's it. That's right. Okay. This is the Virginia proposal for the Declaration of Rights. And if you read the city's brief, you'll see that the city agreed with us and with just about everybody that Virginia's proposal was the model for the Second Amendment. That's what Madison worked off of. It's important to note that of all the state ratifying conventions that had Bill of Rights demands, there were only 2 rights that were common in all the demands. And those rights were the right to arms and the right to free religious exercise. In comparison, double jeopardy, I believe, only got 1 demand. So this was a very popularly demanded right, and this is how Virginia demanded it. Virginia's, look at 17th is highlighted, but let's look at 15th. 15th article says that the people have a right peaceably to assemble. Okay. 16th, that the people have a right to freedom of speech, and so on. Okay. 17th, that the people have a right to keep and bear arms. So we see the structure here clearly it's within a Bill of Rights, and the same language is employed to secure individual rights. Now there are some other concepts in there. Standing armies are bad, a very popularly held idea, and of course that in all cases the military should be subordinate to the civil authority. That's a reaction to the experience in Massachusetts specifically, where the royal governor was also the military commander of the British and did some bad things, including disarming the people, which was very irritating to the revolutionaries.
Before we leave that
sure.
slide, I want to make
okay.
which is just, I just want to note before Joel leaves that slide that the rest of the first sentence of the 17th, after that the people have a right to keep and bear arms, semicolon, that a well-regulated militia composed of the body of the people trained to arms is the proper, natural, and safe defense of a free state. So that the body of the people trained to arms and a well-regulated militia are wrapped into the same sentence with the right of the people to keep and bear arms. You almost never see those concepts disaggregated in the discourse that takes place at this time.
Well, if we look at the Fifth Amendment, which got ratified, we see different concepts there. We see a right against the taking of property without just compensation. Sadly, we have to do some work on the public use aspect of it. But in the same Fifth Amendment, you have a grand jury indictment right. 2 very disjointed concepts. Interestingly, in the Fifth Amendment, we do see language that was employed conditioning certain things upon service in the militia. People had a right to presentment or indictment by a grand jury in all cases, except those arising in the militia when in actual service. Again, the militia when in actual service. So we saw that Madison knew how to condition rights based upon militia service in explicit, unmistakable fashion when he so wanted. But here at least we see that the operative language came in a Bill of Rights that indicated that there were specific rights. Now, Virginia had another, I don't know if it's on the same slide or if we can scroll down to it, because there was another set of amendments that Virginia presented. Can we get to the other Virginia amendments? It's in the same document. No. Okay, you can't scroll that. Okay, it's a slide, not a thing. Well, in any event, take my word for it, there was, and you can read it in the briefs, it's even in the city's brief. After the Bill of Rights amendments that were demanded by Virginia, they also had a list of other amendments. In fact, at the very bottom, let's put that slide back on. See amendments, back at the very last line, amendments to the body of the Constitution. If you were to go beyond that, you'd see another list. The first list is what they called Bill of Rights. The second list is what they called other amendments. And number 11, amendment number 11 there, explicitly had the language about undoing Article 1, Section 8, giving the states the power over the state militias. I wish I had, it was in my brief, which I didn't bring a copy of, unfortunately. I thought it would be in the slide. But in any event, Virginia also proposed what is claimed that the Second Amendment did, which is to give back the power over the militia to the individual states. And that, of course, was voted on, and it was voted down. And so we do have this notion, yes, it's true, the other side is correct, the militia clauses were controversial, the Anti-Federalists wanted to undo the militia clauses, but that was proposed separately. Why would Virginia propose the same thing twice? These are very smart people. Clearly the 11th Other Amendment and the 17th Bill of Rights Amendment related to different concepts. Let's go to my next slide real quick. I don't know if you can read that. It's a little small here. Okay.
It's impossible to read.
Well, this is notes that we don't have. There were no court reporters sitting in the well of the First Congress, unfortunately, but we do have Madison's notes in the speech where he introduced the Bill of Rights, and he spoke about these are private rights, and he had some notes. And in the notes here, you see he's talking about problems with the English Declaration of Rights. And the court's majority opinion, if you read it, does an adequate job, an excellent job actually, of showing that the Second Amendment right to keep and bear arms was the traditional English right to arms. It was an English Declaration of Rights. And it was the idea to take the English Declaration of Rights and improve upon it. There were certain deficiencies in the English Declaration of Rights, and here Madison talks about what some of those deficiencies are. He says, well, mere act of Parliament. The English Declaration of Rights bound the king. It did not bind the Parliament. That's one of the problems. A few other problems. And then at the very end it says, attainders - arms to Protestants. The idea is that if you look at the English Declaration of Rights, only Protestants had the right to arms. This was seen as a difficult limitation, and the idea in the Second Amendment was not to limit the arms to Protestants or Catholics or some subset of favored members of the population, but rather to the people. And let's go to the next slide that I've got. That's not it. That's not it.
Is it Madison's proposal?
No, yeah, the Madison.
That is Madison.
No, there was another one. It's kind of small. Yeah. Okay. Look and see how what Madison is doing here with the structure of the Constitution. If you look at your constitutions today, at the very back of it, you'll see a list of amendments, 1, 2, 3, 4, and so on. That's how it came to be. But originally, when the Bill of Rights was proposed, that was not the plan. Madison believed that each amendment would be interlineated into that part of the body of the Constitution to which it most related. And so you see, for example, that a lot of the individual rights are stuck in Article 1, Section 10, where you have the rights to, in the original Constitution, to habeas corpus, and a right against ex post facto clauses, and so on. You see some of these rights inserted, and then you see that the Second Amendment right, the right of the people to keep and bear arms, is inserted where? In Article 1, Section 9, between clauses 3 and 4. Well, those are the other individual rights provisions of the Constitution. If Madison meant to undo Article 1, Section 8, clauses 15 and 16 of the Constitution, which is what the other side claims, if Madison really wanted the Second Amendment to undo the militia clauses, then this language would have been inserted next to the militia clauses. But of course, it wasn't inserted next to the militia clauses. It was inserted next to the individual rights provisions of the Constitution. So we can see the text, the structure, the way that Madison evolved the Second Amendment, that there are plenty of psychoanalytic tools, if you would, that show that actually there was no intent to undo the militia clauses. How much time do I have? 30 seconds, great. It's always 30 seconds, so that's good to know. Finally, I want to note one thing. and that is the practical meaning of the Second Amendment as envisioned by the city, and I believe is envisioned by Walter here today. The idea that, say, Louisiana, if they were upset with the federal response to Katrina, could empower people in the militia to walk around with whatever arms they wished, and there would be a Second Amendment right to keep such arms pursuant to state authority. Well, what that is an argument for nullifying federal gun laws at the state level. This is a sort of kind of a nullification argument. Remember, we had this debate back in the 1830s with Senator Calhoun, and did states have a right to nullify congressional enactments that they didn't like? And while I'm sure that in Washington, D.C., perhaps in New York City, people would like that version of the Second Amendment, I think you would see under that version of the Second Amendment certain states at least declaring, well, everybody's in the militia and nobody has to follow federal gun laws. And that would be actually kind of scary to some extent. So I'm not sure that's what the Second Amendment meant. And of course, there's a great deal of history that relates to the militia clauses and the original intent, which is to give the Congress the exclusive military authority of the United States, and that states do not have the right to opt out of congressional mandates about military action. And we've seen lots of precedent throughout the court's history, from Houston v. Moore in 1820 all the way through the 1980s in Perpich, that talks about how the federal government really does control the U.S. military, and there is no sort of state exemption under the Second Amendment or anywhere else. So anyway, with that, I think we should go to the discussion. Thank you so much.
We actually just shared this little marks. I'm just going to.
Well, thank you. This is truly the battle of the documents. I wanted to, Travis, if you could start collecting questions, and Julie, if you've got any from the webcast, if you could bring those up to me. But as we're collecting questions, the one that I wanted to pose to Walter and to Alan is, what documents are not legitimate for the court to use, and did they use them in Heller? What should be excluded from this debate?
Well, I think it's nothing should be excluded. I think there was another discourse going on. There is a sense of a natural law type right to self-defense and to the possession of weapons for self-defense that you see in Blackstone, and you see it. You see some statements of this time. You see more of it after this period leading up to the Civil War and the 14th Amendment. That, to me, is a discourse that is, it's out there. It's not the Second Amendment discourse as I read the history, so that it's somewhat misleading. And there's also a strong discussion in the founding period of the right to revolution. But that's not a right that is encapsulated within the Constitution of the United States or its amendments. Indeed, treason is made a capital offense by the Constitution of the United States. The framers, the Constitution was a very conservatizing document and did not embrace in the Second Amendment or anywhere else the right of revolution. So I think that some of that natural law talk or discourse is not part of the sort of states' rights protection of the state militias that was at the heart of the admittedly awkwardly phrased Second Amendment.
I'm going to have to disagree about the relevance of Blackstone, I guess. I think it's highly relevant what our English ancestors thought were their natural inherent rights. Clearly, if you look at all the documentation at the time of the founding and ratification of the Constitution and the Bill of Rights, if you look at the history of our revolution, there was a great sense among the people in the Americas that they had certain inalienable rights, and that those rights had been protected under English law for some time, but that Parliament and the King had started to usurp their authority, to trample on these rights, and it was the entire project of this nation to secure these ancient rights in a document of liberty, basically, that secures individual freedom. And this is foremost on the mind. It was the reason why we started this country, and it's a reason why we should always be mindful to our history, to see what our conception of rights might be. I mean, all of us are for some concept of rights. Nobody here is against having rights. We may disagree about what rights we have or to what extent they should be protected. but it's always a useful starting point to look at the history, to see what traditionally were considered the rights of Englishmen and later the rights of Americans in the early republic. And going forward, perhaps we have a more expansive view of rights today, which I welcome personally. We apply rights to more and more people. We don't have slaves anymore. Women are now full participants in our society. These are good developments. And it's always been the American project to expand the scope of rights and to apply them more vigorously and take a more expansive view of liberty. But we have to start somewhere, and the original understanding of what our core rights are is a good place to start.
Thank you. There was a bit of discussion in Justice Stevens' minority dissent of post-enactment legislative history, and this question relates to that. It asks, what do you make of, one, the majority's rejection of the various earlier versions of the Second Amendment, and two, its review of the 19th century commentary observation, what Stevens calls post-enactment legislative history of its meaning? Why don't we start with Alan, and then we'll go to Walter.
Well, the legislative history, the competing drafts, the various things that were considered and rejected by the Congress, that has less persuasive merit, because of course those things did not get enacted. We can sometimes look to rejected language to actually see, to make the opposite point, that, well, the language was rejected, perhaps they didn't want that, as I've made the argument earlier with respect to the 11th other amendment by Virginia. There was a motion in the First Senate to add the words "for the common defense" to the Second Amendment after arms. That was voted down. So we can play this game in both ways. And for lawyers, it would be great fun to go into any legislative enactment. Imagine the fun we can have with CERCLA and ERISA and all these other gargantuan federal legislative projects if we were to look not just at the text that Congress enacted, but all the various things that they rejected and try to find some meaning in that. So I think it was proper to give that a little bit less weight. The other side plays the game a lot with Eliot's debates, with things that were said about the conscientious objector clause. We can play that game too, and in fact we did to some extent over the course of the case. So I think that's less useful. Now, as far as what the early commentators thought, that is important, because these are people who were alive at the time of the ratification. These are people for whom the framers were within living memory, and it's an example of original public meaning. It's an example of the understanding that people had of the language and what effect it had. It would be strange indeed if we had one version of the Second Amendment or any other constitutional provision that meant to everybody one thing from the time of the ratification all the way through Tucker's treatise in 1803, Rawls' treatise in 1825, onward through the Civil War, and suddenly we get to the 1970s really, and it's a collective right and means something else entirely. That's not really a good way to look at dicta in unexamined cases in the late 20th century, rather than to see what very smart people who were involved in the process and thought about it professionally thought at the time it was actually done.
I would just add that I think what happened here is a melding of two separate lines of analysis. One, you can make an argument that the right to have weapons for personal use, hunting and recreation, or more importantly, defense of home and family, is a part of the liberty that ought to be protected against governmental interference by the 5th and 14th Amendments. Sort of natural law, liberty interest created in the way, or recognized in the way, that Griswold against Connecticut recognizes the right of marital intimacy and the use of birth control within that intimacy. You can make a case of that. I don't think there's enough weight to those notions for this court, given its approach to constitutional interpretation, to find that kind of liberty interest. And then there's the text of the Second Amendment, which was about preserving the states, shackling the new Congress so that it couldn't strip the states of guns and the people of the states of guns that were needed to maintain the state militia. And that these are melded together so that you have the quotations about the right of self-defense, and you merge those with the text, and you through the alchemy, I would say, of the merging of these two lines, you have what appears to be a textual enshrinement of a liberty interest that wasn't at the heart of what the state ratifying conventions were about.
Thank you. There's a question here that essentially goes to any surprises. Were there any sources that surprised you that the court used that you think that maybe they shouldn't have or that you didn't think of? I personally was very surprised that they used Elliott's debates. And Alan, you use this. It's commonly used in legal discussion. However, no historian will use Elliott's debates because they know, based on Jim Hudson's work, who's the curator of documents at the Library of Congress, that Elliott used sources, scriveners from the state ratifying conventions that were of disrepute. They would, John Marshall and Madison said that they read speeches that they gave in Elliott's debates for the first time once it was published. They were known partisans that took the notes and then published them. They were all Federalists. So they essentially edited what was said and made things up after the fact. And so Elliott's debates should not be used. And I was surprised not only that the court used them, both sides of the court, but also that Elliott was misspelled by the court. So why don't we address this question here? Walter, why don't you go first?
Well, whatever the problems are with Elliott's debates, unless there is a better source of the state ratifying convention, and there is. Oh, okay. Well,
John Kaminsky's documentary history of the ratification, which we have on ConSource.
All right. Well, then I don't know. Then excellent. Well, they should have gone to. Obviously, they should have gone to ConSource. I think the state ratifying conventions are absolutely indispensable to the understanding of the Second Amendment. You know, the proposal of the Constitution transferring control over the state militias and over the arming of the state militias to the Congress, widespread opposition to that expressed in the state ratifying conventions, almost vehement opposition to that, demands for an amendment to give this to take away from Congress the power over the militias, and this amendment that Madison sees is responsive to the concerns reflected in those debates. So I thought you were asking why were the state ratifying conventions relevant, but you were asking why they went to if they should have gone to ConSource for that highly relevant information, and they would have been directed to better sources.
Yes, definitely. If any justices or clerks are watching, ConSource next time. In any event, let me answer the question real quick, and then I'll respond to something Walter said. There was one source that surprised me because I don't believe it was cited in any of the 67-odd amicus briefs. It wasn't something that we saw where we would have used it. There was citation to English usage, I believe, in Parliament of the phrase "keep and bear arms," which was new to me when I read the opinion, and I read a lot of material on the Second Amendment, and I don't believe I saw that cited anywhere. So obviously the Supreme Court, while they don't, I'm sure they rely on ConSource, they also rely on other things and do an excellent job. To respond to something Walter said, it's important to remember what the Bill of Rights was about and how it came about politically. The Federalists won. The Anti-Federalists lost. Everybody knows this. The Federalists absolutely dominated the first Congress. The Constitution was eventually ratified. But they were smart enough to understand that winning wasn't everything, that the country would not be a success unless the Anti-Federalist concerns were addressed and these people were mollified in some way. And that's why Madison went back and decided that, yes, indeed, we do have to give them this Bill of Rights. They didn't have to do it, but it was seen as a good idea. And so we're going to give back, we're going to ratify a Bill of Rights that secures uncontroversial things. Remember, the original criticism of the Constitution from the Anti-Federalists was you have a big central government that oppresses the people and takes away all their rights. The Federalist response was along the lines of, don't worry, Congress has no power to establish a religion. Congress has no power to take away people's arms. Congress has no power to do all these things. Why in the world are you worried about Congress searching your house? This is silly. And the Anti-Federalists, though they weren't aware of the Commerce Clause at the time and how dangerous that was, they said, no, we want a Bill of Rights. If it's so uncontroversial, let's have it in writing. And eventually Madison agreed. Now, Madison was going to agree to, and did in fact agree, to the uncontroversial things. that we have a right to freedom of worship, that we have a right to have security in our homes, that we have the right to keep and bear arms. You know, certainly one of the top two most demanded rights. But Madison was not going to agree to, and had no need to agree to, and was politically not beholden to agree to any radical change in the structure of the Constitution. And so while Bill of Rights provisions that were uncontroversial and happily agreed to were ratified, provisions such as the militia altering provisions that were proposed and hotly debated by the Anti-Federalists were voted down, because at the end of the day, Madison was perhaps one of the more radical of the Federalists. I mean, the Federalist Society chose to have him as the silhouette of the organization. There's a reason for that. This was Mr. Federalist, and he was not going to devolve federal authority back to the states within months of ratification of the Constitution. So the idea that the Second Amendment was somehow a way of undoing the Constitution that had just been ratified, I don't believe is supported by the political reality at the time.
Playing microphone hockey here. We have time for one more question, and this relates to future cases. What documents are relevant to the upcoming incorporation cases?
Well, I think there'll be a lot of relevant documents leading up to the proposal of the 14th Amendment. Incorporation is going to be a big issue, but and in fact, we made an argument, the district-specific argument, that depended upon the notion that the court might not incorporate this right, and if the states were free, if the states were going to be free and local governments were going to be free to regulate guns, then legislation enacted either by Congress or by the district government, either one, but was specific to the District of Columbia, should be treated like local legislation and not subject to the Second Amendment's concern about federal national interference with local decision-making about arms. But the opinion shows no signs of backing off of incorporation. I mean, I think that is we see where the court is going. One of the things that is interesting about the incorporation debate is that there was a lot more talk about the right to keep and bear arms as an individual right after the Second Amendment and before the 14th Amendment. I think Joel would agree with that. One of the things that strikes me about the case in terms of sources is that I believe that one source of decision-making in this case was cultural popular expectation. It has come to be believed by a large segment of the public, rightly or wrongly, let's not debate whether it's true or not, but it's certainly a widespread belief that the Second Amendment guarantees a personal individual right. And that expectation had become so entrenched in the years since U.S. versus Miller said this was a militia-related right, that I think that set the framework for the court's discussion and influenced the degree to which the court did not show much hesitation or restraint in the way the right is articulated. I mean, they may well have. We had some hope that they would send the case back and say, though there's an individual right, we have to decide the degree to which guns, concealable weapons in a densely populated urban area pose such a threat that the availability of other weapons, rifles, shotguns, strike down any ambiguity about trigger lock to make sure you can use your rifles and shotguns. We'd have to send it back to see if is that an adequate substitute given the degree of the harm. They didn't. They took, I think, a more absolutist approach, the way Hugo Blank does with the First Amendment, defining some things outside the definition of the amendment. But within the amendment, within the right, it reads as an absolute right.
Well, I wouldn't say the Second Amendment's an absolute right, and I've gotten a lot of nasty mail from people who disagree with me on that. That's fine. As far as the 14th Amendment incorporation debate, the documents that will be most relevant will, of course, be the ones related to the 14th Amendment ratification and debates. Eliot was not around by the 39th Congress, and so I think we're going to see more accurate, and I believe in this particular context, more useful sources of congressional debates, because if you look at the authors and sponsors of the 14th Amendment and their statements, they were unambiguous. Look at what Representative Bingham said, what Senator Howard said on the floor. It was crystal clear and unmistakable that the 14th Amendment was intended to incorporate the Bill of Rights as a whole, as against the states, and specifically one of the rights that the radical Republicans in the 39th Congress were most interested in incorporating was the right to keep and bear arms, because at the time we had a large number of people recently freed from slavery who were being oppressed by the states, and the primary tool of oppression was to disarm the freedmen. And so you saw Congress was concerned not just in the 14th Amendment debates, but also in debates relating to related legislation, the Freedmen's Bureau Act, the Civil Rights Act of 1866, and so on. The right to keep and bear arms was very important, and they wanted the states to obey it. And all the original documentation, I believe, would show that. There's nothing at all in the 14th Amendment debates that suggests that the Bill of Rights was not to be incorporated. I know Justice Black, for whom Walter clerked, was one of the, I believe, 12 justices who over the years have felt that the Privileges or Immunities Clause directly incorporated the entire Bill of Rights as against the state. The Supreme Court, of course, tragically made a mistake in the slaughterhouse cases and went the wrong way on that. I believe that should be re-examined, and perhaps it will be re-examined in one of the incorporation cases. However, employing a modern Duncan v. Louisiana selective incorporation test, we see the Second Amendment is plainly incorporated. This is a right which has deep Anglo-American traditional roots. It's a right which is popular amongst the states. The trend is certainly in the direction of protecting the right. And so all the factors that one might look to in the court's modern selective incorporation doctrine would tend to show the Second Amendment's incorporated, and I believe that will eventually be the result. The only hiccup along the way, we do have a small collection of cases in the Supreme Court that went the wrong way, but those cases are all from the mid-19th century period, which was many, many years before we had any incorporation. Some of these cases have held that the First Amendment's not incorporated. Clearly that's not good law anymore. The Supreme Court has hinted at that in the Heller opinion. And so I do look forward to incorporation. It's coming sooner rather than later.
The final explanation for Heller was that the court, having let all the terrorists out on habeas corpus the previous week, wanted to give everybody a handgun to defend themselves the last day of the term.
Well, perhaps the court wanted to not annoy those members of the public that had guns. But I don't know.
Just wanted to make a small ex post facto clarification for those non-lawyers participating here in the audience and online. Incorporation simply refers to whether or not the Constitution or the Bill of Rights applied to the states versus the federal government. Initially applied to the federal government. In Heller, it wasn't an issue because D.C. is governed by the federal government. For the states, it's a different issue. I just want to thank our panelists very much for their participation. And Alan mentioned the sources for the 14th Amendment. Those are not yet up on ConSource. If you would like to help make that possible, please talk to me.
Thanks. Thank you so much.
I too would like to thank our panel. It's interesting to me personally to hear Justice Black's name invoked so frequently here. My dad clerked for Justice Black a few years before Walter did. And I asked him how he thought Justice Black, who really was the most liberal member of the Warren Court, would decide this case, and he thought he would have decided it with the majority. It shows you, what today's, yesterday's liberal may become today's conservative. I don't know. This has been a wonderful, wonderful session. We thank you, Lorianne, and your group. And just would tell you all that in the fall, on October 30th, we're going to have the distinguished Dean of the Yale Law School, Harold Coe, speaking here on questions of human rights and international law. We look forward to seeing you then. Thank you so much. Thank you, panel.
Thank you, John.